Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the Hall and Wilcox Smarter Law podcast for the second episode in our series about artificial intelligence and legal professional privilege, where we're discussing the impact of AI on LPP. My name is Katie Moore. I'm a partner in the projects group and I'm here again with my colleague Lauren Saporovich. Welcome, Lauren.
Hi again, Katie. So thank you for having me, and I really look forward to speaking about what the Australian courts and regulators are saying about this topic for this session.
For those of you who listened to our first episode on the 10th of March, we discussed this topical and evolving question of whether the use of AI, particularly OpenAI, can waive legal professional privilege. In this second episode, we're going to explore the use of AI as well as the position of the Australian courts and regulators with respect to this use and its impact on legal professional privilege. As you know, AI is transforming the way we work and the speed and pace of change is huge. The judiciary in Australia is only just starting to come to terms with the use of AI and its impact on legal professional privilege. We expect this to be fast evolving in the next months and years. In today's episode, we're going to discuss the current position in Australia. Lauren, just before we start the current position in Australia, it's probably worthwhile doing a quick refresher on first principles.
Sure, Katie, thanks. As we discussed in our last session, we all know that AI can be of great assistance to everyone. It really helps improve efficiency, but really from a practitioner perspective, we need to be aware because uploading confidential information to AI can inadvertently waive legal professional privilege. So just to step back to first principles, as Katie was saying, legal professional privilege protects confidential communications and documents between a solicitor and client where those communications were made for the dominant purpose of giving or obtaining legal advice or for actual or anticipated litigation. Now, if a party acts in a way that's inconsistent with that privilege or the maintenance of confidentiality, for example, by disclosing legal opinion or advice, then the question becomes, has the privilege been waived? And this is what we're unpacking today. So this is where AI comes into it, because you really need to make sure to exercise care to ensure that you're satisfied with terms and conditions and the level of privacy and confidentiality of the AI you're going to use if you're going to use AI in practice, because otherwise you may venture into the territory of inadvertent waiver of privilege. And now, just to refresh our memories, our references to the public AI versus the open AI is the difference between AI that's openly accessible to the public, for example, via the internet, whereas closed AI, as its name denotes, is not accessible to the public, and information usually within those closed tools typically remain within a controlled environment.
I think it's interesting to note that just because you're paying for the AI doesn't mean it's closed. I know I've had discussions with clients about the use of your open and closed AI, and they're like, oh, we use the paid ChatGPT, therefore it's closed.
Exactly.
I don't think it is, and you probably need to go and check the terms and conditions of use, because just because you're paying for a slightly better form doesn't mean that it is closed.
No, exactly. And if we're talking about ChatGPT, ChatGPT saves a user's chat history and uses that conversation and those conversations to train its other models. And now, just because you've paid, it might just be a premium sort of service, but it doesn't necessarily, unless you've checked those terms and conditions and says otherwise, it doesn't necessarily change it from its usual model of generative AI in terms of learning from what you've inputted. And if that inputted data is confidential, or privileged, it's still learning from that and using that to determine its responses to you, but also to others.
Yes. Yeah. So check the terms and conditions is probably the first thing to do.
Exactly.
So let's turn our attention to the Australian courts to look at some of the decisions that have come out. Not unsurprisingly, we all know that there have been cases where lawyers have filed non-existent cases that AI's made up, known as hallucination. And unsurprisingly, the court system that has thought the most about the use of AI and whether it waives legal professional privilege is the family court. a lot of people in the family court are self-represented, and they probably just run it through AI to get all of their pleadings that they hand into the court. So the court has thought about the use of AI, and in particular in the context of waiving professional privilege. Do you want to take us through the first case, Lauren?
Sure. So we're going to have a bit of a chat about two specific cases because, as Katie said, there hasn't been too much discussion about this topic, but there has been a start and initial warnings coming from the family court. So the first decision is one of the Federal Circuit and Family Court from late last year called Helmold and Maria number 2. And this is an appeal from parenting orders in which Mr. Helmold was challenging the orders ultimately made in his absence as being a denial of procedural fairness. Now, they ultimately dismissed this appeal, but in so doing, the Federal Circuit and Family Court commented on the documents the appellant had filed. Now, the appellant's documentation had included incorrect authorities in cases that couldn't be located, so hallucinations, as Katie mentioned before. And it was determined that the result of these errors was because generative AI had been used in the preparation of these documents. Again, unsurprising considering who is in these spaces and the fact that this is helpful. This is a helpful tool to people. Interestingly, in addressing this issue, the court looked to our neighbours and our friends in the UK to try to borrow from them and their cautions that have been recently endorsed about adherence to professional obligations and the use of AI, particularly from the High Court of Justice. And that's
probably good at this point to note that in one of the coming episodes, Lauren will be talking with some of our UK colleagues about the position that's been taken in the UK. So that's something to look forward to.
Yes, for sure. There's quite a bit of movement in both the UK and the US. Interestingly, in the US, which we touched on in our last podcast, there's been quite significant commentary. So we'll unpack that in future episodes. So watch this space. But in Helmold, to go back to that case and what commentary we do have, the court observed that the input of documents into a generative AI program which stores, collates, replicates data may waive privilege or fall foul of requirements that certain matters be treated as commercial in confidence. And importantly, they went on to say that these issues warrant extreme caution. So while we don't have definitive answers, we have a warning of extreme caution.
And I see that the court's been quite cautious in that they're saying it may waive privilege.
Yes.
Maybe that's the reason why I'm not a judge. I'd probably think it does waive privilege, but we'll follow the family court, which says it may waive privilege, and we need to be really careful when we're using this technology because it's never going to replace your professional judgment and verification.
No.
It's a helpful tool, but we need to be able to use it in a special way.
Exactly. And that's why you'll see, and we'll come to, and I think we touched on in our last session about how a lot of regulation that we've been seeing and a lot of guidelines in these spaces have strongly suggested and recommended that AI not be used in the decision-making process because nothing can replicate professional judgment and professional verification.
Yes. And then it's interesting to note that there was a second Federal Circuit and Family Court decision, Mertz and Mertz, which actually cited the Helmold case, the one we've just been talking about.
Yes.
It was about professional responsibility in an AI-enabled legal environment. Without going into too much detail, I think it's important to note that the court reiterated the position in Helmold and said there is a risk that entering draft documents into AI will result in a breach of a particular section in relation to undertakings, but importantly, and or give rise to a waiver of legal professional privilege. So the courts are attuned to this problem and this issue.
Yeah, the temperature of the courts definitely seems to be to caution against the entering of documents into AI, particularly to OpenAI, for the fear of waiving privilege. But as we've said, there hasn't been a definitive determination on that.
So let's turn our attention to there's guidance from the courts. There's no sort of definitive statement that it does waive. In our previous episode, we touched on the fact that there are a number of significant updates from tribunals and government. let's have a look at the Victorian Law Reform Commission report that was tabled on the 3rd of February in 2026. Do you want to take us through some of the key issues that arose from that report, Lauren?
Sure. So that was the culmination of approximately 2 years of investigations, discussion with key stakeholders throughout Victoria, and culminating in about 30 recommendations to ensure the safe use of AI in Victorian courts and tribunals, and the recommendation of 8 overarching principles to guide this safe use and to try to maintain public trust in the courts and tribunals. So these 30 recommendations, and again, they're recommendations, so it'd be very interesting to see what's adopted, where the courts and tribunals take this and how much they adopt. But for example, they include things such as encouragement of an agreed national approach to AI regulation.
That would be great.
It would be great. And interestingly, I might just quickly raise a point before we get further into the report. But interestingly, we were discussing yesterday, Katie, there's been a joint position released across a couple of the states, and again, guidance across peak professional bodies in Victoria, WA, and New South Wales, where they've made a joint statement saying that to maintain client confidentiality, solicitors cannot safely enter confidential, sensitive, or privileged client information into public AI chatbots or co-pilots or any other public tools. And it warns that if practitioners do elect to use generative AI tools, they should carefully, and we come back to what we've discussed before, carefully review the contractual terms of the platform to ensure the information will be kept secure. So there is a combination of agreement amongst some of the states, and this report we're talking about wants to take that further.
Trying to get all the states to agree on something, as we know, is very difficult. But I think something with this emerging technology, it would be great if they could come together and all head in the same direction. I thought it was really interesting, slightly off topic, but I thought it was really interesting that one of the recommendations was that judicial officers should prohibit the use of AI in their decision making.
Yes, exactly what we touched on just before. It comes back to the fact that nothing can replicate human awareness and human consideration. And hopefully that keeps us in profession and in our jobs for years to come, Katie, and this doesn't ever get replicated or amended.
So what are I think it's probably central to the report of these 8 principles. What are the 8 principles that they said should guide people in implementing the use of AI?
Yes, so these principles are recommended to support and guide court users, officers, tribunal staff, everyone. And these include things like impartiality and fairness, accountability and independence, transparency and open justice, which is key, and that delves into the AI perspective in terms of being transparent with your use.
Yep.
Contestability, procedural fairness, privacy and data security, again, very key for our consideration. The access to justice for all, efficiency and effectiveness, and then human oversight and monitoring. Again, human oversight and monitoring, very important for AI considerations and very topical.
You can't replace critical thought with AI.
No.
Which is, as we said, lucky for us.
Lucky for us, but I think some people are potentially trying to do that, hence we get into the realm of hallucinations.
Yes. So what were the ultimate recommendations that the Commission made?
So they made, as I said, 30 recommendations, of which some of them incorporated the suggestion to amend the Supreme Court guidelines for the responsible use of artificial intelligence. And this is, again, very interesting to see how much this is adopted. But their recommendations as part of that were to do things like update the Supreme Court guidelines for definitions. As we've discussed in this podcast and in our previous session, the definitions of public AI and closed AI aren't a uniform definition but are defined in the report, as we previously mentioned, and getting on the same page about what is public and what is closed is a good starting point, and that's not currently done in that regard. So they've suggested things like that. They've suggested that court users use it in a certain way to ensure accuracy. Again, we get to hallucinate, to try to offset hallucinations, fact check, proofread, verify resources. They've said things like a person making a witness statement, character reference, or similar statement should verify its accuracy and ensure that it represents your view. And guide, again, as you've said, judicial officers should prohibit the use of AI for decision making, and that the courts should do things like notify people whose rights are affected by a decision made or influenced by AI. Are we getting into a realm where that could be the basis of an appeal? Who knows where that will lead, that sort of thing will lead us.
I thought it was really interesting, which really touches on what we've discussed before, was that one of the principles was that you need to be aware that AI can retain the information you input.
Yes.
And I think that every time in legal practice you use AI, you should bear that in mind, that whatever
Yes.
I'm putting in here, if I haven't checked the terms and conditions, that may be retained. And
exactly.
You don't know where it goes.
No, you don't. And flowing from that, they also recommend and note that for public AI tools, users need to make sure that inputs are appropriately anonymized and generalized, because exactly as you've said, you don't know where that's going to go. And again, they do come back to lawyers should not enter sensitive, confidential, or privileged client information into public AI tools. And it really comes down to we need to comply, we as practitioners need to comply with our obligations to maintain client confidentiality. So that's at the forefront of one of their guiding principles, particularly around data security and privacy.
And I think it's something that is probably more relevant to junior practitioners who have been used to using AI when they're at university, and those who are now studying law, you probably used it at school, whereas you and I, Lauren, without giving away, I'm considerably older than you, but we didn't use it. So we already have this thought in our mind, that there could be, it's not a part of it, hasn't been a part of our everyday life until recently. So I think it is something, in particular, junior practitioners beware of what sort of AI you're using when you're preparing documents.
Interestingly, a point to note about that is that what is someone using personally versus professionally? Because as I think we've touched on this just between you and I before, Katie, but is someone just double checking something over their lunch break through ChatGPT as they would, as opposed to at work, sitting behind their desk, then reverting to Harvey or otherwise, and that's more of a closed, safe, licensed product, and they've compared, thus they think that they've satisfied their obligations, but it's a determination that needs to be, and this comes back to a determination across the board. This is across the board professionally, but across the states, but also making sure to adhere to the safety and sensitivity of information, just by way of course, if you just randomly Google something the same way we would randomly Google something, because it's not the same as Googling something, unfortunately.
No, it retains it completely. So the position in Victoria, I think we can probably sum it up. In May 2024, the Supreme Court issued guidelines for litigants for responsible use of artificial intelligence in litigation. That once again touched on the appropriate use of AI, and it also encouraged self-represented litigants and witnesses to include a statement about the AI tool that they use in any AI-generated materials.
Yes, and this is the guideline. These are the exact guidelines that the report is proposing amendment to.
And the Law Institute of Victoria, the peak body that regulates lawyers in Victoria, released an ethical guideline entitled Ethical and Responsible Use of Artificial Intelligence. And it did say, once again, I feel like we're a bit of a broken record, that a key risk in using AI is that information included in questions to the AI may be reused or disclosed by some AI providers. Noting that the Law Institute recorded that ChatGPT had confirmed a data breach in March 2023.
Exactly.
So it's been going on for 3 years and we're slightly behind.
Where's that information gone from pre-2023 and to whom?
Yeah, that's a really good point. And the Law Institute also advises that in order to reduce the risk of a breach, do not put confidential client information or information subject to LPP into AI, except in the case of a closed AI system.
Exactly. So all roads point to what we've discussed, but there hasn't been a definitive adoption of that or a definitive judicial consideration of it yet. But the temperature seems to all be consistent.
Yeah. So I guess what we can gather from all of this is that there's not one uniform position yet regarding the waiver through the use of AI in Australia. There's some warnings that have been put out by the federal court. The current position will surely shift, and we expect that there'll be more judicial consideration of this issue in the coming months and years. And in the interim, and without any sort of overarching guidance, we come back to the position, if in doubt about a AI tool's ability to maintain confidentiality, do not put any information into AI.
Exactly. And if in doubt, come and ask.
That's right. So, looking ahead, in the coming weeks, we'll be speaking with special guests from our international colleagues, including from the UK firm Mills and Reeve, where Lauren spent some time, to discuss the position in Australia versus the UK and the US and hopefully Singapore, and unpack similarities and differences internationally. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe to our podcast wherever you get your podcasts.
Great. Thanks, Katie.
Thanks, Lauren.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.